Hello, this is Professor Keith Ross from the John Jay College of Criminal Justice. This is another in a series of lectures for the college classes that I'm teaching this semester. This lecture is going to be for my Introduction to Criminal Investigation course. This is going to be Chapter 8, Eyewitness Identification Procedures. Pretty quick chapter, some stuff that we do need to know. One of the things before I even start is that the human brain is this amazing thing that can process information and recall information instantaneously. However, our brain differs than a computer because a computer can always draw up that same information consistently on a time to time basis. One of the things that we know about the brain is that as soon as we observe something, we actually start to forget about it. Now, if we're taking this into the context of the criminal justice system, a lot of times what we're talking about is we're talking about people in crisis, people in trauma. So, what the brain does to self protect is to start forgetting those traumas, those incidents that cause trauma, that cause that fight or flight instinct, the release of cortisol in the bloodstream. So, one of the things that we have to remember with eyewitness procedures is that we have to take into account that time really is of the essence because as soon as we observe something, we start forgetting it. Uh, I could probably ask each and every one of my students, if you were in front of me, what did you have for dinner 3 days ago? Now, probably some of you can recall that, while others couldn't. It's sort of the same kind of premise. So I'm just going to start right on slide number 4. Eyewitness misidentification comprises about 72%. We're talking 3/4 of those convictions overturned by DNA evidence. That comes from the Innocence Project. If you want to Google them, you can find out what they do. And that's basically what they do is that they utilize DNA to overturn what is considered to be wrongful convictions. So a lot of times we as investigators can gain convictions with eyewitness identifications, but are they always the most consistent and accurate? Well, that's a question. When investigators make errors, or when we receive erroneous information, an innocent person is put in prison, while the real perpetrator is out on the street further victimizing the public. These exonerations seem to be happening with more frequency as advances in technology develop. So, with the advent of DNA, with the advent and the progress of processing crime scenes and trace evidence and breakthroughs in forensic science, we're relying more on objective data filled evidence as opposed to these eyewitness or testimonial pieces of evidence. Now, I'm not saying that testimonial evidence is not probative, it can absolutely be probative, but it's not 100% the game. For me, I always believe that if you're going to utilize testimonial evidence, and you should, there's no reason to exclude it, but it should also be backed up with some type of physical evidence or some type of forensic truth. The Due Process Clause, the 14th Amendment, protects the citizens of the United States from police identification procedures that are too suggestive. I'm going to talk a little bit more about that when we start talking about what show-ups are and what lineups are. Eyewitness ID procedures, investigators sometimes need to convince the victim to cooperate with the investigation. So we might have a victim that's not willing to really give forth a statement, probably because of trauma. Think assault victims, think sexual assault victims, think witnesses to homicides. They might not want to talk. They might not even be able to talk. They might not have processed this incident. They might be trauma bonded. The longer it goes, again, as I said, the faster the victim's memory or the witness's memory starts to fade. So investigators must act quickly. So now I'm on slide 7. Slide 7 is really the important one. Now he lists three. I'm going to actually give four. There are show ups, arrays, lineups, and mugshots. So again, if you want, you could exchange this acronym SAL to MALS. So we have mugshots, arrays, lineups, and show ups. However you want to remember it, doesn't really matter to me. What I would say, here's an easy way to remember it. A show up, we have somebody in custody, but we don't know who it is. A photo array, we have an idea who it is, but we don't have that person in custody. A lineup, we have an idea of who it is and we have that person in custody. And then mugshots, we don't know who it is, we don't have anybody in custody. That's really sort of an easy way to remember that. So the first thing I want to talk about are show ups. The prompt on the scene presentation can be confrontational of a suspect singly is a one-on-one display to an identifying witness for the expeditious identification and or early release of an innocent person. Must be a reasonable amount of time. The courts have sort of given us some direction. About an hour is a reasonable amount of time to conduct a show up. Now, this is how a show up works. Let's say an incident takes place where someone gets robbed of their cell phone. The offender runs away. The victim starts screaming, help, help. Someone calls 911. 5 minutes later, the police arrive. They start asking those NIATWI questions. What happened? When did it happen? Where did it happen? Did you see who did it? Did anybody else see it? How did it happen? And the police can ask that person, that victim of a crime, to get into the police car. There's no issues with this. There's really no liability because the police are acting in good faith. They're acting within the scope of their duties of employment, trying to prevent crime and trying to apprehend violators of the law. So they take the person around and they conduct a canvass. So they're driving around. Now, let's say they drive around and then the person in the back, the victim of the crime, points out and says, that's the guy that did it. Well, that's a show up. However, nothing operates in a vacuum. So let's say we're talking about some sort of violent offense like robbery. The police officers that are taking the report, especially if this has taken, 2 to 5 minutes in the past, it is reasonable to assume that that perpetrator, that offender could be caught. So, what police will do is they will transmit a description over the radio saying it is a male white, approximately 5'7", wearing a purple and white shirt, blue jeans, blue shoes, medium build, bald with a goatee. So maybe 3 blocks away, another police car goes around and finds a person that fits that description. So they radio to the car that has the victim and say, can you swing by here? So now the police say, we're going to drive somewhere. That's all they say. Now, they drive around and they get to where the other police car that is quote unquote detaining this person of interest right now because they have reasonable suspicion that this person committed either a felony and or a penal law misdemeanor. Now they go and they drive around and one of the police officers points at the person being held and says, "Is that the guy?" And the victim says yes. Well, that would not be a good show up. And if you remember in Chapter 1, Introduction to Law and Justice, that very last slide, in the pre-trial or suppression hearings, there is those Wade Gilbert Stovell hearings. Well, one of the things that they're going to examine is how did the victim find the perpetrator? How did they point them out? More likely than not, this identification would be excluded because it would seem to be leading that the police should not have said, is that the guy? What the police should have said was something to the effect of, do you see anything? Something very, very general, something not leading, and let the victim point out the person. Now, if the victim points out the person, well, then we have probable cause to effect an arrest. So must avoid leading the victim and or witness. Cannot be suggestive. The person that is being detained cannot be handcuffed, cannot be placed in the back of a police car. You cannot do a show up at a police precinct, uh, anything like that. As a matter of fact, usually what happens is um, you want that person sort of hands around, not bound. You don't even want police all that close to the person, although there is the chance that the person might run, because you want to make sure that you get this probative show up, this probative identification. Show ups are not used when the victim and the suspect know one another. So there's no reason to conduct a show up if we have, let's say, some sort of DV, domestic violence issue between a husband and a wife. A reasonable person would assume that a husband and a wife know each other. A confirmatory photo could be used in those instances. So when we're conducting this show up, we're going to do something called a field view. When searching for a perpetrator, investigators use what's called the field view. Investigators conduct a field view when the victim witnessed, generally in an unmarked vehicle, doesn't have to be unmarked though, but could be, drive past larger crowds of individuals in a public place to see if they recognize anyone. So this means we don't have anybody in custody. We don't have anybody detained. We're on a fact finding mission. Hey, do you see the person? Do you see anything? A field view is not a show up since they can be conducted hours, days, and or weeks after a reported crime. It's basically sort of a surveillance, and there's no reason to really have to articulate to the courts why police conduct surveillances. Investigators cannot single anyone out in the group, nor advise the victim witness take a closer look at these two guys, these three guys. Again, you can't do that. So the easy way to remember show-ups, usually show-ups, we have somebody in custody, but we don't know who it is. We don't know if this is the actual offender or perpetrator of the crime. Photo arrays. Photo arrays, think of photo arrays like you would think of lineups, and everyone has at least seen a lineup on TV where you have like 5 or 6 people stand, and then there's a victim or a witness on the other side of a wall with a one-sided mirror, things to that effect. Arrays are photographs. Think about them as a photograph type of lineup. When the suspect is not in custody, but again, we have an idea who it is. You do not know who the suspect is, but you have an idea who it is. When you have an idea who the suspect is based on past experience, these are not for fishing expeditions. The fishing expedition would probably be in the mugshot book. The photo array must be vouchered as evidence. Now, with the photo arrays, what you're going to do is if you have a perpetrator, if you have a person of interest, you're going to use that person's photograph, and then you're going to find 5 other people that reasonably resemble the perpetrator. Because if you do not do that, the photo array, again, via the Wade Gilbert Stovell hearing, will be deemed excluded and or admissible. The investigator must record where the photos were taken from and who the individuals are. So they could very well be perpetrators of crimes. They could be people off the street. Oftentimes, especially in the old police academy that was on 20th Street, they would use police recruits in these photo arrays, and they would also use them in lineups. So steps in conducting this array, a minimum of 6 photographs must be used. Again, we have 1 perpetrator plus 5 fillers that reasonably resemble our perpetrator. Again, all photos should be of persons of similar makeup. So we're talking sex, age, race, and build. There should be nothing in the photo to make the suspect stand out. Victim witnesses sign the photo identified. The law enforcement officer cannot lead the victim witness. Take a good look at number 3. Is number 3 the guy? That's, again, leading. So again, we want these 5 fillers to reasonably resemble. Now let's say the perpetrator is bald. Now we have 5 people that look like our perpetrator, but 3 of them have hair. Well, what do? Well, maybe you find a picture of the perpetrator, or you take a picture of the perpetrator with a hat on, or maybe a do-rag, and then you put that do-rag on everybody else. So we're trying to stabilize the field, make the field as even as possible, so that if our victim or witness picks out number three, that will stand up in court as probative evidence. With multiple victims and witnesses, each new photo array must be shown separately. So let's say we had a ring of four people conducting cell phone robberies, and all four were present at the scene. Well, we're going to conduct four separate photo arrays. We're not going to put all four perpetrators in one photo array with two fillers. That would be deemed excluded. Do not allow witnesses to confer one another. And this is something, as far as criminal investigations go, I've been saying on and on again. If you have witnesses, we need to separate the witnesses. We don't expect our witnesses to remember the events the exact same way. And there probably should be some nuanced differences between statements, but what we don't want is them filling each other's holes in their memory. Never assist the person when choosing someone in this photo array. Take a look at these 6 pictures, and that's it. Have witness sign the photo they choose, as well as the date and time. A positive ID gives you probable cause to bring this person in, and then conduct a lineup. This idea of a rogues gallery, this is your mugshot. This is when we don't know who it is, we don't have anybody in custody. Collections of photos non-sealed by court order, retained by police for future identification purposes. Photos can be kept as wet photos in a file, or they are usually kept now in an electronic database. I'm going to skip slide 16. I'm going to go to 17, lineups. We have an idea who it is, and we have somebody in custody. The suspect does not have an absolute right to counsel to an investigatory lineup, meaning you have the right to an attorney, but you don't have the right to an attorney at a lineup. Now, you can request your attorney to be there, and the police will reasonably accommodate. However, there are some constraints with that attorney. The United States versus Wade, so this is part of those Wade Gilbert Stovell hearings, lawyers only at post-indictment lineups. Now, they can be present, but they cannot make suggestions. So let's say the investigator wants to put the perpetrator in spot number 2. The lawyer cannot say, I don't want my client in 2, I want him in 4. The lawyer can say it, but the police are not obligated to oblige. Again, must be under arrest to be forced into this lineup, at least 5 fillers, or consent, at least 5 fillers and suspect. Suspect is allowed to choose their place in the lineup. And again, the police can say go to spot number 2, but the police don't even want to do that. Hey, buddy, 1 through 6, what number you like? I like 5. Is 5 your lucky number? Go stay on 5. Photos must be taken of this lineup, and the viewing room must have one-way mirrored glass. People present in the viewing room: the victim and or witness, the case investigator, the person that's in charge of the lineup, the investigator supervisor, and the ADA, the assistant district attorney, the person that's going to prosecute this case. They will be in the lineup as well. There are contamination issues. Investigators cannot afford to have victims, witnesses see the fillers, the other people, uh, or the suspect ahead of time. So we want to keep, if we have a victim or a witness that is going to view a lineup, we want to segregate them from wherever we have this offender and the fillers, because we don't want them to see them first. Victims' witnesses must be kept away from all TV and electronic devices. So if they have cell phones, we're going to politely ask that they shut them off. The last concept is something called a double-blind lineup. Now, this idea is starting to gain foot in jurisdictions. I believe it's utilized in Minnesota. There's talk about utilizing it in New York. Same as the investigatory lineup, except that the investigators conducting the lineup have no idea about anything about this case. So they don't know who the suspect is. They don't know who the fillers are. Now, the reason why double blind lineups might be used is because it has been alleged that an investigator that's investigating this case, that's conducting the lineup, might give some sort of subliminal signal to the victim or the witness as to the position of the perpetrator. So let's say the suspect is in spot number 2. Well, the investigator could say something like, "Okay, I'm going to let you view this lineup. Tell me if you see anything," and then blink twice. Well, that might be a subliminal signal, or maybe tap twice, or something to that effect. So, what double blind lineups do is that they ensure the fairness of the lineup if the fairness is an issue. That's basically it for this chapter. It was a pretty quick chapter. Just to wrap up, lineups, we have somebody in custody and we have an idea who it is. Show-ups, we have somebody in custody, but we don't know who it is. Photo arrays, we don't have somebody in custody, but we have an idea who it is. And mugshots, or that rogues gallery, we don't have anybody in custody and we don't really know who it is. That's going to be it for me. Have a great day, and I wish you all well. Take care.